Such was my eagerness to get to Newton, I forgot to make one point in relation to Herx. The Secretary of State at paragraph 97 of a written case, electronic page 170, appears to suggest that the Minimex benefit in Belgium did in fact address some Article 3 needs. It seems to be a suggestion that there's a kind of proto-test of predominance that's being applied by the CJEU. And with respect, it's impossible to see how that's a sustainable reading of the judgment, given that at section 12, the CJEU asks itself whether, and I quote, the legislation at issue must in any event satisfy, in particular, the condition of covering one of the risks specified by Article 4, it's now Article 3 of the regulation, and answers that question at 14, stating that the Minimex, and again I quote, cannot be classified under one of the branches of social security listed in that article, and therefore does not constitute a social security benefit. In other words, it's categoric that none of the Article 3 risks are triggered. And the Advocate General's opinion, Advocate General Darman, is yet more explicit to that effect. See section 8 of his opinion, which starts at page 2018, and in particular the passage at 2019. So properly read, the case says the exact opposite. Herx turns upon the fact that the legislation addresses and only addresses poverty or the need for a subsistent income. And it's that fact that makes the subsequent cases where there is a hybrid character material. And those cases start with Newton and Hughes. Because in these cases, the benefit in question is triggered by the fact that there is both poverty and one of the Article 3 risks being met. Now, Newton concerns the old mobility allowance. It was a cash benefit that preceded what then came to be called, in the charming abbreviations, DLA MOB, or the mobility component of DLA. It was a cash benefit paid to those with a disability that rendered them unable to walk or presented mobility difficulties. And effectively, the cash benefit was intended to support things like the mobility scheme, Motability scheme, where you've got a motability vehicle, matters of that kind. And the argument in Newton was entirely about characterisation. Was that mobility allowance to be characterised as an invalidity benefit, in which case it was common ground that the precursor to Article 7, the residence waiver rule, would bite, or was it social assistance, in which case there would be no such rule operative? And the UK was effectively arguing that the social assistance function predominated because the benefit was designed to alleviate personal needs, the personal needs of the disabled person, rather than providing compensation for reduced earning capacity in consequence of the disability. And they were saying, therefore, apply a predomination type test, it's social assistance. The CJEU had none of that. At paragraphs 14 to 15, the reference for which is 2283, and then at 19, the CJEU concluded that because it had a hybrid function, a dual purpose, it was to be treated for that reason as a coordinated Article 3.1 benefit. Now, much the same terrain was then covered again a matter of months later in a case called Hughes. And the context of Hughes is much closer to the present case. It concerned family credit, which was said to be a family benefit. And what a team the government fielded in that case. The argument was presented by Eleanor Sharpston QC, as was, leading someone called Brian Kerr QC, as was, and a junior called David Panic. The A team was basically brought out to attack the hybrid benefit analysis, and the tussle was between characterisation as a family benefit and social assistance. And again, the reference for the case is 2144. The CJEU applies its hybridity approach at 14 to 15, at 16, note in particular the last sentence of paragraph 16. It's 2144 is the case, my lord.
That's right. You want us to look at
14 to 15, 16, and then the reasoning 17 through to 20. And in particular, it's the operative
Page.
2160. One looks at 20 in particular. It's by virtue of that second function that a benefit such as family benefit falls within the category of family benefits defined in Article 1UI, which is the equivalent of our J now, and hence relates to the risk referred to in Article 41H, which would be 3.2J, or whatever the equivalent provision is. And so, notwithstanding there was the fact of what was described as, in paragraph 19 above, a dual function, that was not enough to displace the operation of the regulations. And it was this case law that led to the creation of the SNCB category I showed you in Article 70. The Hughes type social assistance add-on case was addressed in that first limb, in the first definition of special that I showed you in the Article 70 definition of what constitutes a special benefit. And the Newton disability scenario is addressed in the second limb, alternative limb, of what constitutes a special benefit. So this case law...
So the effect, how did that follow through then? Are you saying that if it, in both cases, the effect of introducing the SNCB category is, and listing it in the annex, is that none of it is exportable?
Correct. The legislature has introduced a response that enables hybrid benefits to be taken outside the operation of the usual disapplication of residence rules, so long as they are in fact special benefits as defined, condition 1, so long as they are in fact non-contributory, condition 2, and so long as they are listed in Annex 10, as now is. Now, what happened after this case law was that there were a series of cases arguing about whether or not things that were listed in Annex 10, or Annex 2A as it used to be, were in fact special non-contributory benefits. There was a time when it was thought effectively simply the listing of the benefit in Annex 2A was effectively legally conclusive of status. And then there were some German and Austrian care cases, one called Jauch, one called Molinar, that said no, each of the conditions, the three conditions, have to be substantively satisfied. And if you don't satisfy the test of the benefit in fact being special, then the fact that it is listed is immaterial. It's not a special non-contributory benefit, and it can be subject to the usual disapplication of residence rules. And it was that line of case law that then gave rise to the disputes that came to the court in Commission and Parliament. But before we get to that, in the context of severance, can I just show you this case law being applied in the context of child benefit and CTC? You've heard a lot about the Commission and UK case, but let me now take you to it. It's electronic page 1850. The case concerned infraction proceedings against the UK for the use of what was called the habitual right of residence test, or the HRT test, as a precondition for accessing a benefit. And one of the benefits to which that test, habitual residence test, was applied was child tax credit, and another was child benefit. And both of these were at issue in this litigation. The legality...
I'm sorry, Mr. Delamere, I'm going to ask you to start again. I've got a technical problem. You could just start introducing this case again, please.
Of course, my lord. So, It's page 1850.
Yes.
It concerns infraction proceedings against the United Kingdom for using a habitual residence test as a precondition for access to child benefit and CTC, child's tax credit. And the legality of that habitual residence test was looked at through two distinct optics. Optic one was its compatibility with Regulation 883/2004, our regulation, and Optic two was its compatibility with the Citizens' Rights Directive. That's Directive 2004/38, you'll see in the headnote. And as a precursor to the decision upon the permissibility or justification for the use of the HRT test, the court had to decide whether or not child benefit and CTC was a family benefit within Regulation 883/2004. So it wasn't the main prize in the case, but it was clearly an important component in the court's analysis. And on that, the conclusion was very clear. You can see that, first of all, from the holding one in the law report, since child benefit and CTC were granted automatically to families which met certain criteria, without any individual and discretionary assessment of personal needs, and were intended to meet family expenses, they constituted social security benefits within the meaning of Article 3(1)J, i.e. family benefits. That was in the face of the UK arguing, and you can see this at page 1892, sorry, I've got the wrong reference. It's paragraph 52 I'm looking at. It's page 188, 1888. I'm sorry, I've got the wrong 51. Yes. Yes, it's 51 on page 1888. The UK adds that the social benefits at issue display in any event some characteristics of social assistance, even though this is not a condition that must be satisfied in order for the principal and Bray's case, which is the CRD case, which concerns social benefits generally, to be applicable. In the UK
to have a characteristic of social assistance, that means having a low income. Is that yes?
Absolutely. So what they're saying is, look at these benefits, they look like social assistance. Notwithstanding that, the judgment...
I'm awfully sorry. Could you just repeat which paragraph?
It's paragraph 51. Right.
51, right.
51, I said 52. My apologies. Managed to confuse myself and you. So that's the submission that was being made. Look at these benefits, they look like social assistance. The reasoning of the court starts at 54 on page 1889, and the operative passage is at 59 to 61. As regards tax credit, it's also undisputed it's a cash benefit paid to any person responsible for one or more children, the amount of which varies according to family income, the number of such children, and other factors concerning the individual situation of the family concerned. Despite its name, child tax credit is a sum. In other words, it's a cash benefit, not a tax set-off, which the competent authority pays periodically to recipients and which seems to be associated with their status as taxpayers. The benefit replaced a range of additional payments which were made to persons claiming various income-linked maintenance allowances in respect of children for whom they were responsible, and the overall aim was to combat child poverty. Now, that paragraph and that reasoning can and should be transposed entirely to the child element, which has all of those characteristics, not least it replacing the CTC element as opposed to the elements that the CTC had itself replaced. And of course, as Mr.
So were they saying the fact that something is only paid to people below a certain income threshold doesn't automatically mean that it's social assistance?
Exactly so, my lady. Once you have a dual set of conditions to pass, you are both poor and supporting children, that's enough to turn it into a family benefit.
But these are all looking at individual benefits.
Yes, my lord.
So it depends on your argument that this should be regarded as an individual benefit.
I totally accept that. I'm just pointing to this case law to show you, and it's particularly apparent from the next paragraph, paragraph 60, that what happens is that the dual benefit case law from Hughes is applied, and notwithstanding the dual function of the old CTC, because it was means tested, it was about child poverty, it was about poverty and a payment to children, notwithstanding that dual characteristic, it's still analysed as being a family benefit. So Hughes is applied at 60, and the result at 61 of applying those criteria, that Hughes and Newton line of case law, is that it's a coordinated benefit.
How do you determine whether it's got dual characteristics? Do you look at the elements of the benefit, or do you look at the policy behind the benefit?
You look at the elements of the benefit,
Right.
my lord. Obviously, you can look at the policy behind it if it helps illuminate the legislation, but in this case, you don't really need to go much beyond Section 12 of the Welfare Reform Act.
So the overall aim of which
Section
was
10.
to combat child poverty, the last few words of 59, they're derived from the elements of the benefit.
Well, indeed, they are self-evident from the face of the Welfare Reform Act.
Yeah. Okay, we're not looking at why the proposal was put before Parliament for enactment or anything of that sort. It's an objective test by reference to the
Absolutely.
elements of the benefit.
And if you go to Section 10, which we haven't taken you to yet, and this is maybe a convenient moment to do so, page 381 of the electronic bundle,
So we're leaving this case.
we're leaving this case.
So just going back to the point that, I mean, if it were the case that any time any kind of benefit is only paid to people on a low income, if that was enough to make it social assistance and hence not addressing any of the risks in Article 3, that would knock out, one would imagine, a huge number of social security benefits.
In these increasingly financially straitened times,
Yes.
more and more benefits.
More and more
are being
benefits. So what they're saying here is, just because you only pay this child benefit or CTC to people on limited income isn't enough to say that it's social assistance and not addressing one of the risks in Article 3.
Absolutely right.
You look at what you still have to look, even though it's means tested in an objective way, you still have to look at what risk it's addressing.
Absolutely. So look at the triggering condition, and the triggering condition for the child element is Section 10 of the Welfare Reform Act, which is at page 381, which we've taken a long time to get to. It's headed Responsibility for Children and Young Persons. The calculation of award of universal credit is to include an amount for each child or qualifying young person for whom a claimant is responsible. That's the basic rule. That's exactly the same as the basic rule in CTC. And then at 1A, but the amount mentioned in subsection 1 is to be available in relation to a maximum of 2 persons. That's the two-child rule. And then subparagraph 2 provides for the regulations making or identifying the additional amount, which is the regulation and the additional amount Mr. Castle showed you this morning. So it's impossible to look at those criteria, which are exactly the same as the criteria that operated for CTC, and to say if there were no other change, I'll come back to my Lord Hamlin's point, there were no other change, that this would not remain a family benefit. So let's suppose it was lumped into universal credit as a completely freestanding element. That surely couldn't alter the former analysis that has applied. The only thing that has changed now is that in order to get the child element, you first have to show that you're entitled to the standard amount. In other words, it's become a parasitic entitlement, a derived entitlement, much like the child bonus in the Latchett case. So that is the approach adopted in relation to hybrid benefits. It's enough if one of the triggering conditions it may not be the only one, or even the most important, is one of the Article 3 risks. There is no test of predomination applied. The only place that predomination is applied, and the case of Tolley, if you want an example, which is Authorities Bundle, tab 79, electronic page 2408, the only place the test of predomination is applied is when you're choosing between which alternative Article 3 risks to use to characterise the benefit. Now, that being so, the Newton-Hughes case law and the SNCB category to which it gave birth is a fundamental problem for the Secretary of State, because there is only two logical outcomes. There are only two logical outcomes when faced with a regime like universal credit, which clearly employs an Article 3.1 risk as a factor to determine eligibility to some payments. The first analysis is the predominant purpose, or predominant theme approach of the Secretary of State, which just says, look at the benefit overall, it's social assistance. It matters not if an element in it is triggered by an Article 3 element, because it's still overall a national anti-poverty benefit. And that is an approach that has no authority to support it at all. Or, just as in Lacheb, you look at the subordinate payment on its own merits and you apply the Hughes and Newton criteria, and if they say that it is a family benefit, then the regulation applies only to the extent of that benefit, and any relevant residence rule is disapplied, just as it was for CTC, and just in the way that HMRC did for CTC. Mr. Castle showed you their guidance. They plainly understand how to do it. So the problem for the Secretary of State with this case law is that tacitly the approach that they advance invites departure from Hughes and Commission and Parliament and the dual character case law. It invites departure from the solution that the legislature has provided to this problem, which is listing such a benefit as an SNCB. And remember the criteria, it's supplementary ancillary to the risk of poverty, plainly directed at this type of problem. And it effectively says that by making the allowance subordinate to a general allowance payable only to those in poverty, you step out of the analysis under the regulation altogether. And that's in circumstances where, as I said this morning, the practical reality is that many of the people claiming CTC would have been claiming general subsistence benefits anyway, that have been claiming income support or working tax credit. That's the second reason. The third problem is the case law on severance. And I will repeat my not selling my case too high, uncharacteristic for me, in relation to Commission and Parliament and Bartlett. The reasoning in these cases is extremely sparse. But the background to this is relatively shortly stateable. The mobility allowance that was at issue in Newton was consolidated in the 1990s with another benefit called the care component, which was the old care allowance. And what happened was that these two formally distinct benefits were consolidated into a single piece of legislation that had a single claims structure. So if you wanted to apply for either benefits, you applied for them at the same time. There were separate criteria for mobility allowance and care allowance. They had separate, unrelated criteria for eligibility. Sometimes you'd be eligible for one, sometimes you'd be eligible for two, sometimes you might be eligible for both, and there were varying levels of payment reflecting degrees of disability or degrees of care need. What then happened is that after those cases of Yauk and Molinar that I mentioned, people started to say that long-term care benefits, even though they had been listed in Annex 2A, now Annex 10, weren't in substance special benefits. They still were in substance care benefits. And that was the conclusion of the Court of Justice in both Yauk and Molinar. The regulation then came to be amended. And when the regulation was being amended, the Commission proposed the removal of a wide range of benefits from Annex 10, as now is, on the basis that applying the substantive criteria in Yauk and Molinar, the test of what was a special benefit, those benefits weren't in fact special benefits, and they shouldn't have been listed in Annex 10. So they were complaining that Finnish and Swedish and UK benefits were listed in Annex 10 as SNCBs when they shouldn't be. They took out the benefits in their proposal. The Parliament and the Council reinserted the benefits into the list, and when they did so, the Commission...
Who took out the benefits? The regulation amended the... There was a regulation.
The regulation amending Annex, what is now Annex 10, had taken out... The Commission had taken out the Swedish, Finnish, and UK benefits. The Council and Parliament reinserted them in the final text. And the Commission challenged the final text because they said it included benefits that shouldn't be listed. So that's the background. Most of the benefits in dispute in this litigation were care allowances. So all the Swedish and Finnish allowances were care allowances. The UK benefits at issue were threefold. They were carers allowance and attendance allowance, conventional caring allowances, much like the Swedish and Finnish allowances, and DLA. And DLA, of course, had two components. It had the mobility component, which looked like the old Newton benefit, which had generated the creation of the SNCB category. So it was the successor to the very benefit that had led to the invention of the SNCBs, and a care component that looked like carers allowance and attendance allowance, and looked like it wasn't an SNCB. And what the CJEU did was it applied its case law on, so the case is at page 1825. The Advocate General's opinion is at 1793.
Which do you want us to look at?
If you look at 12 to 13, you can see the core of the dispute.
Sorry, you're with the Advocate General?
No, in the court, please.
So 1825.
It's page 1832 in particular. So this is in the court's judgment, and it's explaining effectively why the Commission had refused to include certain things in the new list. So drawing the criteria, applying the criteria drawn from Yauk and Molinar, the Commission didn't include certain benefits, including certain invalidity benefits, certain disability benefits, and certain care benefits. See that at 12 to 13. And then if you go to 56 at page 1843, you'll see the start of the substantive reasoning of the court. And here you'll notice a composite summary of the test on what is a social security benefit for the purposes of the regulation, the old Article 4.1, now 3.1. And the case cites, and I just ask you to note this because it's a point relevant to the Court of Appeals judgment, it cites Herx, but then it goes on to cite Newton, Hughes, and Molinar. So all of the cases that look at dual benefits and whether or not dual benefits are coordinated by the regulation. And it said, was on the basis of that case law, which takes account of the German care benefits, the court held in Molinar that the benefits were in fact to be regarded as sickness benefits. And then after that, it applied that reasoning to the Finnish and Swedish care benefits, finding them all not to be special and therefore not capable of listing, before then turning at 65, page 1845, to the UK benefits. And it says of all three, those benefits are all by nature, although only partially so in the case of DLA, care allowances. UK is defending them on the basis of their purposes to help promote independence, social integration, etc. So they're running the social assistance, personal need type argument again, which has failed in Hughes and Newton. They say the criterion which determines entitlement to those benefits is the need for care. Entitlement to the GLA or AA does not depend on being unable to work, and the three benefits at issue are granted regardless of the level of the income of their recipients, simply at different rates. Contrary to what the UK asserts, so that's the argument that's made, only the DLA can be considered to include a social assistance component. The other two benefits at issue have a single purpose, akin to the Swedish disability allowances, so they fail the substantive test. And then at 68, accordingly, those three allowances, as well as the preceding allowances, must be regarded as sickness benefits, even though the DLA includes a distinct part relating to mobility. That's a distinct part, limited to something that could be an SNCB.
So if they are sickness benefits, does that means they can go into Annex 10?
No. If they're just pure sickness benefits, it means that they won't have the requisite special character in order to be listed as an SNCB. No one said this stuff was easy. It's really quite confusing.
So the argument here is whether there was power to put them into Annex.
Yes.
Essentially, yes. So what is being said is the carer's allowance, attendance allowance, and the care component of DLA could never be listed as a matter of substance in the relevant...
Right, because even though they are benefits directed at something in Article 3, they're not sufficiently special.
Special under the test.
Right. And just remind me what makes it special. Just in
I'm going to have to go back to the
no,
wording.
oh, don't worry then, I can.
It's the wording of Article 70 of the regulations.
So the Annex 10 benefits are a subset of benefits within the meaning of
Yes.
Article 3.
They're a special subset of coordinated benefits, which special rules apply to, that entitle you to disapply the usual rules of residence waiver. Then at 69, it goes on, as the Commission indeed observes, the mobility component of the DLA, which might be regarded as a special non-contributory benefit, is severable, so that that component alone could be included on a list in Annex 2A as amended if the UK decided to create an allowance which concerned that component. So they're saying, in principle, it could be listed. So if you're looking at the three component stages, they said component stage 1, is it special, is met. Component stage 2, is it non-contributory, is it met? Yes. Component stage 3, is it listed? No, but it could be listed. And for that reason, at 74 and following, they limit the temporal effects of the judgment in order, in effect, to give the UK time to amend the regulation to have DLA mobility component listed in the relevant annex.
Just where do they deal with that?
Under temporal effects of the judgment. 74. It's necessary, however, for the court to state the straightforward annulment of the inclusion of DLA in the list in Annex 2A as amended would lead to the UK being forced to grant the mobility element of that benefit to an unspecified number of recipients throughout the Union, although the fact that that part of the DLA is in the nature of a non-contributory benefit cannot be disputed, and it could be lawfully included in that list as a non-exportable benefit. In other words, they're saying the first two criteria have been met, you should be given time to meet the formal requirement of having it listed.
So when they're talking about the amending the regulation, they mean the domestic regulation to split out?
No, they mean amending the listing in Annex 10 of, as now is, of the regulation that identifies the benefit in question that is an SNCB.
In effect, everyone's been acting under a misapprehension. UK could, if it had wanted to, have sought protection for its social security system by getting the DLA mobility allowance element included in Annex 10. We're not, by our order now, going to preclude them from being able to do that.
Exactly so.
They did
Exactly so.
Right, but they don't require the United Kingdom to make any change to their domestic treatment of it.
They don't. And what happens is that in parallel with this case, a reference is made by, I think it was the upper tribunal in a case called Bartlett. The UK hadn't secured, in the intervening time, an amendment to Annex 2A to separately list DLA mob. And the question came back before the court, effectively being, or at least one of the questions was, is the listing of DLA as a whole in Annex 2A sufficient to provide a listing for the DLA mobility component? In other words, can we take the listing of DLA in Annex 2A and effectively sever that so we understand it as relating to both DLA mob and DLA AA, and where it's DLA care component. Where it's DLA care component, you put a line through it because it can't be a special benefit, but you leave the bit that's DLA mob.
I'm sorry, you did say, but I didn't take it in. Are you saying the question is severability of what is listed in Annex 10?
That becomes the principal issue in the Bartlett litigation, because the Bartlett litigation starts from the predicate that the question of whether or not it's a special benefit is met in the case of DLA mobility, and they say, see our judgment in Commission and Parliament. And then the real issue is the current listing for the whole of DLA sufficient for it to trigger the effects of non-waiver of residence clauses? And they conclude that it is. Now, here, if you thought the reasoning in Commission and Parliament, that I've just taken you to, was sparse, the reasoning here is yet sparser still. The material analysis is at page 1659. (20 to 21). The first question is, can mobility allowance be considered a benefit on its own account within the meaning of the regulation?
Where is this in paragraph 21?
Paragraph 20.
Right.
It is first of all necessary to determine whether the mobility component of DLA can be regarded as a benefit on its own account. And they simply answer that saying, yes, because that's what we concluded in Commission and Parliament. And that's why I say what we have is a statement of conclusion. We don't have, beyond the language of referring to a distinct part, which you've seen from Commission and Parliament case, we don't have anything that looks like some kind of detailed operative test.
It does say, if the United Kingdom decided to create an allowance which concerned that component alone.
That's what it says in 21. Mike.
Yeah.
Absolutely. But
So
then,
did the United Kingdom create an allowance which...
no, they didn't.
Well, they didn't need, so you're saying they didn't need to, because although it just said in Annex 10 disability living allowance, that had to be read after Commission and Parliament as only listing the mobility part, because that's the only special bit.
Absolutely, my lady. And to answer my Lord's question, what's really happening at 21 is they are postulating a test of hypothetical severability. In other words, could you make a benefit that looked like mobility component?
Yes.
And if you could do that, then that was the basis for severance. So you've got 20 to 21.
I see. It follows that the mobility component
Absolutely.
constitutes a benefit.
Absolutely. So what they're saying is...
This rolled up benefit, you could get one element but not the other.
Absolutely. And I hope I...
No, you did say that, but I just confirmed
Yeah,
it.
the big difference between our case and DLA is that the two components are freestanding.
Yes, yes, yeah.
21 to 23 then is where they deal with that. And beyond this test of could you hypothetically make a freestanding benefit, to which the answer is obviously yes in our case, because what does that freestanding benefit look like? It's CTC. Or if you like, CTC with a requirement that you have access to some other benefit as well. They then come back to the listing point at 31 to 32, and this deals with the fact that only DLA is listed. And in very short, terse reasoning, they effectively say that the listing of DLA as a whole is sufficient to list the DLA MC component, which is hypothetically separable, and therefore DLA mobility component is not subject to the waiver of residence.
Right, so it has to be, although it just says in the Annex UK disability allowance, now you read that as just being mobility but not the carer aspect.
I suppose in domestic terms, you unpack the reference to DLA. Well, we know that DLA means mobility component and a care component. They're separate things. They're both subsumed in the listing. You then get out your blue pencil and you blue pencil the bit that says care component and you're left with mobility component. That's effectively what they're saying.
Right.
what
Whereas
has
they
happened-
could have said, no, you put DLA as a whole in, part of that is not special enough, and so you lose
Yeah.
you lose everything. It's
could
all,
have.
yes. That wouldn't make, but what would that have, that would have made the whole allowance exportable, or it would have made it not
It
exportable?
would have made it
or-
exportable until such time as you created a separate benefit and listed it separately. But that wasn't what they required.
Right.
So the critical thing is, when you put the two cases together, the CJEU has applied an EU test of severance, not very well unpacked, I accept, at two stages. It's applied it at stage one in deciding what the special component is, and the special component is only mobility care component. They sever at that stage. And then they apply a second set of a test of severance to sever the actual Annex 2A entry. Now,
Sorry, could you just repeat that? The two stages?
so there are three conditions you need to satisfy to be an SNCB. The first is that it's special.
Yes.
Commission and Parliament applies a test of severance to the first condition, first two conditions, and it says mobility is special and it is non-contributory, such that you could, if you want, list it in an Annex 2 entry. And then Bartlett goes a stage further and applies the same test of severance to the actual entry that's in Annex 2A and says the reference to DLA can be severed so that you're left with DLA mobility component. Now, it's impossible to say, in the face of this case law, as the Court of Appeal has said, and as the Department for Work and Pensions has said, that there isn't any emerging CJEU case law on severance. It may not be very excellent case law, it may not be very clear case law, but an EU law test has been applied to effectively save those parts of a domestic scheme of benefits that are savable and require the export of those parts that require export under the regulations principles. And that is no different to what we urge. The only difference in this case is whether or not these principles of severance apply not to two benefits that are like ships passing in the night, independently existing, quite closely similar in subject matter but not formally linked. Does that test of severance apply to a component that is a downstream element of something upstream? That's the only relevant difference. And we say that that case law urges the conclusion that we supported, particularly when you understand it in the context of the objective test and you understand it in the context of the Hughes and Newton line of case law. Because at all stages, a member state always has the option, if they don't like waiver of residence rules, of listing the relevant component as an SNCB, and that will then end the operation of Article 7.
But only if it's a special one.
Indeed. Indeed. So that then takes me to my fourth reason, form over substance. And I'm not going to wax lyrical on this point. You readily understand the point being made, which is that it can't be that the answer to this case depends upon how you restructure or recalibrate your benefits so as to repackage what were formally distinct elements into one composite whole, and thereby, for that reason and that reason alone, alter the character of what's at issue. It's not complicated on an analytical level to take a number of means-tested non-contributory benefits that address Article 3 risks, so a number of benefits with a common denominator of addressing poverty, and restructure them so that you identify the poverty element in all of them, particularly if you've also got a benefit like income support, which is only about subsistence income, and then to turn what were formerly distinct benefits into add-ons in relation to that architecture. And really, the analysis, as a matter of EU law, can't depend upon those sorts of overarching design choices. You have to look at the substance of what's going on. That then leads on to the floodgates arguments. And you've got my first answer to all of these. The floodgates analysis only really works on the Secretary of State's argument if you start from the premise that the only permissible optic is the system of universal credit as a whole. if you start from that problem, that perspective, then the fact that the legislation in some parts refers to the risk of family benefits or unemployment benefits for other add-ons, that does generate a real problem of characterisation, because there will be different elements attracting different analyses, and you're trying quite artificially to find one analysis that applies to the entirety of the core standard allowance and any conceivable add-on to it. But if you start from a different perspective, which is to say that you look at each allowance which does address an Article 3 risk on its own merits, then those problems fall away. And there is no problem of payment or anything of that kind, no collapse of the general regulation for rules on residence, because just as with CTC, the test of residence is only disapplied when the regulation requires it. So it's only those additional elements, like the Section 10 element, that is indeed properly characterised as a coordinated benefit, that leads to a residence rule being waived. If there's another element or the standard allowance that doesn't attract that analysis and it uses the same test of responsibility, that test of responsibility continues to operate. So many of the Skywall Full arguments are predicated on the acceptance of the Secretary of State's one ring to rule them all analysis. And once that falls down, they fall down too.
But would your case here lead on to a similar result for other elements in universal credit?
Well, potentially, but I would strongly caution against thinking that that's axiomatically going to be the case, because some of the elements appear beguilingly simple on their face, but have actually very, very marked differences. Not least the housing element, which has an increment or appears to have an increment in relation to children. In fact, in its operation, it operates very differently. And the reason for that is housing element is effectively a cap on the maximum housing benefit, if you like, that you can receive. If your private market rental income is below the cap sum, it doesn't matter how many children you have. It's only relevant if you're approaching the statutory cap and the calculation of the statutory cap. So it actually operates very, very, very differently to the child element in play here. So I don't think you can simply say, well, simply because other parts of universal credit refer to children or use children in their calculus, that the same family benefit analysis applies. And we're certainly not making a positive case to that effect. And I fear that's probably a matter for future cases if one wants to get into it.
But the standard allowance, you accept that that is social assistance?
Social assistance.
Yeah.
Yeah, absolutely. Our case is only directed at Section 10. So the Court of Appeal had a couple of extra reasons of their own derivation for supporting their conclusions. The first was that our analysis constituted harmonisation rather than coordination. And frankly, we find that as an argument very difficult to understand, because if CTC and its export is permissible coordination, as it plainly is, and the disapplication of residence rules is plainly permissible coordination, it's all part and parcel of making the single applicable law work. And if the argument is that in substance the child element is the same as CTC, it is no more impermissible harmonisation to do in the context of the child element what was permissible coordination in the case of the CTC. It just doesn't follow. It's just a conclusion that has no logical underpinning to say, notwithstanding the fact that they are in substance the same benefit, if you disapply the residence rules for one, it's coordination, but for the other, it's impermissible harmonisation. So that's a duff argument with respect. The second argument that's advanced is, well, you'd have expected, if there were any principle of severance, for it to have been articulated in the regulation, and because there is no principle of severance expressly articulated in the regulation, it can't exist. And there's two problems with that. First of all, it doesn't respond to the case of Lacheb, where effectively exactly the same technique as severance is being applied by choosing the optic to which you look through. In other words, starting with the narrow increment rather than looking at the benefit as a whole, which leads you to severance in substance by a different means. And secondly, despite what the Court of Appeal says about Commission and Parliament and their attempts to distinguish it, it's impossible to reconcile with the express words of the CJEU's judgment, where they expressly employ a test of severance, an EU test of severance in the two manners I've identified, without there being any foundation for that in the regulation. And it's just no more than the application of principle-based reasoning that requires the identification of a principle of severance. And is that so very different to the common law method? I mean, the common law principles of severance are identified and applied in all manner of statutory contexts. We apply contractual principles of severance in competition law all the time without there being any statutory mandate to do so. So don't, with respect, understand that argument. And then lastly, I do have to point out that the treatment of authority in the Court of Appeal's judgment is sparse in the extreme. It starts with Herx, it then proceeds to analyse Commission and Parliament and Bartlett and the case of CG. There's no analysis of Newton, no analysis of Hughes, no analysis of the SNCB case law on hybrid benefits, no analysis of the SNCB category, no analysis of Lacheb. It simply doesn't address the points that were made and the forensic points that require answering. And the failure to address the case law on hybrid benefits in particular is a signal failing in the Court of Appeal's analysis. So for all those reasons, we say the proper analysis of this benefit, this child element, is that it remains a coordinated family benefit. In terms of disposal, we have two options, the reference to which I'll come, or alternatively, if you find yourself not competent to refer or not wishing to as a matter of discretion and you need to resolve the underlying dispute now, then we say that effectively the revision decision should be set aside, not for the reasons that the FTT gave, which were flawed in law, but on the basis of the facts as found by the FTT, because the FTT found all the facts that you require to determine that Ms Simkova, Markus Simkova, was mainly dependent upon his mother. And although those findings were reached in the context of the wrong test, main responsibility rather than main dependency, they plainly show that he was at all material times mainly dependent on his mother. And if that's the correct analysis, then the revision decision should be set aside. Can I now then turn, with the time that remains, to the reference topics? And I think this is the first occasion in which this court is going to have to grapple with some of the arcana of the withdrawal agreement. I appreciate you got quite close to some of these points in Lipton, but there are parts that are going to be refreshed by these submissions that Lipton did not reach, to paraphrase the old Heineken commercial. The withdrawal agreement, of course, is an international treaty. It's to be treated in accordance with standard Vienna Convention principles. We've set those out in our written case at paragraph 146, and I don't detect much between us and the Secretary of State in relation to those. What is, however, critical in this case is the context for the interpretation of this treaty, because that context, inescapably, is the UK's long membership of the EU and its adherence to and understanding of the EU's sui generis system of international law. And that's of particular importance for two reasons. First, insofar as the stated purpose of the operative provisions of the withdrawal agreement is continuity, as it so plainly is, it's continuity of a known, established body of rules whose content is well understood. And secondly, insofar as the parties agree in the withdrawal agreement itself upon rules of interpretation that build upon such pre-existing EU law and its interpretive method, such that it means very much EU law interpretation as usual, then that is the approach to be applied. And that, very plainly, is at the core of the interpretive method under Article 4 of the treaty. So this is not a case where you're assuming some kind of clean slate before the adoption of the treaty. The withdrawal agreement is going to operate, and does operate, very much as an addendum to, a wrapping up of, an existing sui generis body of law, namely EU law, whose content is well known. The recitals, the two most material recitals, we've set out in our written case at paragraph 147, page 130. It may be useful to just turn those up. You may think this is motherhood and apple pie, but this is, on any view, critical to the construction of this agreement as a matter of international law. And the critical thing is that the first recital is all about providing reciprocal protection for EU and UK nationals, as well as their respective family members, where they have exercised...
Where are you reading?
Page 129, paragraph
129,
129. I said 130.
I had the wrong.
I've misled my note a second time. Lady Blacknell territory.
129.
129 of the
We're going
written
here for the recitals, are we?
Yes, yeah.
Yes, thank you. Sorry, I got the wrong page.
Right.
Where they have exercised their free movement rights before a date in this agreement. And that's quite critical to understanding the submissions. The rights are all preconditioned upon the exercise of free movement rights before the agreement, and to ensure that their rights under this agreement are enforceable and based on the principles of non-discrimination. That's point one. And point two, it's about providing an orderly withdrawal through various separation provisions, aiming to prevent disruption and to provide legal certainty to citizens and economic operators, as well as to judicial and administrative authorities. So those are the key optics when one comes to look at Part 2 and Article 154. Then we come to the provisions of Part 4, and of those, there's definitions in Article 2, including definitions of the term union law, but the critical provision is Article 4 at electronic page 759. Most of these rules are important. 4.1 contains effectively a requirement to interpret the provisions of the agreement so that it produces the same legal effect in the UK and in the Union. In other words, there should be uniformity of result in both the UK and the rump EU. And, as a tool to achieve that, direct effect of the provisions of the withdrawal agreement. You see that from accordingly, legal or natural persons shall in particular be able to rely directly on the provisions contained in or referred to in the agreement, which meet the conditions for direct effect under EU law. So there's a straight renvoi to EU law and its principles of direct effect in Article 4.1. Article 4.2 binds all UK institutions, including judicial institutions, to disapply inconsistent or incompatible domestic provisions through domestic primary legislation. So the UK shall ensure that they can through primary legislation. That's what the withdrawal agreement provisions of UA now do. The provisions of this agreement referring to union law or concepts or provisions thereof shall be interpreted and applied in accordance with the methods and general principles of EU law. So if you're using EU law terminology, if you're describing EU law instruments, it means what it always meant. That's the continuity recital made concrete. Article 4.4, and this is very important for the understanding of the binding effect of EU law under the withdrawal agreement. The provisions of this agreement referring to union law or concepts or provisions thereof shall, in their implementation and application, be interpreted in conformity with the relevant case law of the Court of Justice of the European Union handed down before the end of the transition period. In other words, where the withdrawal agreement operates, CJEU case law binds, and it binds all parties and all courts, including this court, as a matter of this agreement. And then 5 deals with post-IP completion day case law, shall have regard to it. There's then a principle of good faith, reflecting the Vienna Convention principles in Article 26, Pacta sunt servanda, and the Article 31 interpretation provisions. And note that the principle of good faith says it's without prejudice to the principle of sincere cooperation. So both in good faith as a matter of international treaty law and the principle of sincere cooperation, where it's ported in with the operation of any EU law concepts, both continue to operate. Then you get to the Part 2 provisions. We can skip over Title 1 and Title 2 because they're about rights of residence and rights to work. And we arrive at Title 3, which is mercifully short in comparison to Titles 1 and 2. Like Title 1, it works on a rule of personal scope.
Sorry, where did you find this?
Page 772.
Thank you.
Yeah, there was just a moment.
So you have to show that you're a person covered in the terms of Article 30. And it's sufficient for present purposes just to point to A. Now, this is a very different criterion of personal scope to that is used for citizenship and work. Union citizens who are subject to the legislation of the United Kingdom at the end of the transition period, that's a reference to subject to the legislation of the United Kingdom under Article 11 of Regulation 883. In other words, applying the single applicable law test, as well as their family members and survivors. They're in personal scope. So Ms Simkova is in personal scope under Article 31A by dint of the operation of the regulations conflict rules. And that then leads you into what happens in Article 31. And here there is just a straightforward continuation of the previous law. Page 773, Article 31. The rules and objectives set out in Article 48 TFEU, Regulation EC 883/2004 and Regulation number 987/2009, that's called the implementing regulation that provides for administrative committees, etc., shall apply to the persons covered by this title. In other words, it's straightforward, unvarnished, uncomplicated, unconditional continuation of Regulation 883 and all that it requires. And that's only for those in personal scope. But as a measure of how unusual this particular chapter is, you can see, actually, I point out Article 31.2 also carries over with approval all of the definitions used in Regulation 883 to this agreement. So that's where you get the legislation applicable test in Article 31A being the same as the coordinating regulation. So that's the first indicator that this is really quite an uncomplicated renvoi because it's carried over as special terms, all the terms from the regulation itself. But then the second indicator to that effect is Article 36, because this is one of the few areas under the Withdrawal Agreement where EU law remains a living instrument rather than being ossified on the date of IP completion day. There's a slightly complicated procedure to take account of amendments to Regulation 883, and it involves various committees, the details of which aren't important. But in principle, if the regulation is updated, it's the updated post-IPCD regulation that applies, unless there are amendments that make something exportable where it was previously non-exportable, at which point the committee procedure is attracted. But that living instrument provision, which is pretty much unique in the main body of the Withdrawal Agreement to these provisions, it has some equivalent in the Windsor framework. That is a material feature when you come to look at Article 158, because it's an indicator of just how close the continued operation of EU law is intended to be. And that's why we say in our written case that this is both an uncomplicated set of provisions, because compare and contrast Title I and Title II, which take the EU law building blocks and then make substantial changes to them. There's no change here, so it's simple in that respect. And it's unusual because of this dynamic interpretation feature. Then I just need very briefly to show you the provisions of Part 4, page 778, because in this case, Ms Simkova's continued entitlement breaks down into 3 phases. It breaks down into the phase up to exit day on the 30th of January 2020, which is the time period considered in Lipton, because all the delayed boardings in Lipton were before exit day. Her entitlement continues into and through the 11 months of the transitional period, which is governed by Part 4, and then it continues for 18 months after our IP completion date. So that's why we need to look at these provisions. Article 126 provides for the transition period. Article 126, that's page 778. Article 1271 explains the operation of the transitional period and what it will contain. Unless otherwise provided in this agreement, union law shall be applicable to and in the United Kingdom during the transition period. And it's only in consequence of that provision that the power to make a reference to the CJEU continued. And of course, the CJEU to which reference was being made in this period, in cases like the Prestige and CG, cases after exit day, but before...
But is there a definition of union law?
Yes, it's in Article 2, my lady. One goes back to...
So you accept that you say
Page
that
756. So
you say there is a continuing power of this court to refer cases to the CJEU in relation to the pre-exit day period, or all 3 phases?
There's a power to refer up to exit day under Article 267. There's a power after exit day, but before IP completion day.
When you say we're talking about doing it now,
I know, my lady.
yes, so you say that there's a power in relation to the pre-exit day period to refer under Article 267.
It was under Article 127, paragraph 1 of the Withdrawal Agreement, giving continued effect to Article 267 of the treaty.
I think my lady and yourself may be speaking at cross purposes here. I think the point you're making, Mr. Delamere, is that during the transition period, there was a power to make a reference, and that was derived from Article 127, paragraph 1.
Exactly, Mark.
Yes.
Exactly so.
My lady's question is different. It relates to the power now.
I'm coming to that, Mark.
Yes.
But the point I was going to make is this, that during the transitional period, the procedure for the reference has already changed. This goes to the law enforced point, because in my submission, all this stuff about Section 12A, the Social Security Act, is about procedure. It's not about the substance of the law, and it's completely irrelevant. The law changed on exit day, not least because the court to which you could refer after exit day itself changed. Its composition had changed. There were no UK judges on the court. It had different rules of procedure in consequence. It had different personnel. And then the basis for making a reference changes again on IP completion day, and instead of being Article 127 of the Withdrawal Agreement, it becomes only Article 158 in relation to a Part 2 issue. And so, as from IP completion day, that is then where you locate, as a matter of procedural competence, any power to make a reference.
But you were saying that there are 3 phases of her entitlement.
Yes.
There's her entitlement for the period pre-exit day.
Yes.
Then there's her entitlement during the 11 months of the implementation period. And then there's her entitlement to
Yes.
child element in the run-up until the child ceased in education. Now,
Yes.
there's not been any reference made so far, so we're only talking about what power we have to make now. a reference. But are you saying that in relation to those 3 periods of her entitlement to this benefit,
Yes.
that our powers are different?
They have changed, yeah. Regulation 883, the substantive law, has operated entirely unchanged. In the first period, up to exit day, the question is, how is any accrued right in that period incorporated? And the answer is my lady's, my Lord Sales's analysis in Lipton. It's that accrued rights are preserved by Section 3 of the European Union Withdrawal Agreement on the complete code analysis. But my point is that from exit day until IP completion day, the basis for her continued rights is not the fact that they're retained EU law, it is the fact that they are protected under the treaty, under Article 127, and that brings as a consequence the operation of Article 4 in all its glory, including the provision that says that CJEU case law is binding.
During which period is that?
During 11 months of transposition.
During the
So CJEU case law is binding during the 11 months of transposition, and once you're into Part 2, and you're into Article 158, the answer that the CJEU shall give on any reference made under Article 158 is also binding, and that follows because Article 158 tells you so. And that's the last piece of the puzzle. If one looks at Article 158, the key provision at 784, it is plainly modelled on the old Article 267. Its principal difference is it removes the qualified obligation of a final court to make a reference, the old Article 2673 obligation, where it's pure discretion. It's a reference that can be made in a case which is commenced at first instance, not whose facts start after IP completion day, which is commenced at first instance within 8 years of the end of the transition period before a court or tribunal, that's a term of art in EU law as explained by the CJEU in many cases about what constitutes a court or tribunal, a question is raised concerning the interpretation of Part 2 of this agreement and where that court considers that a decision on that question is necessary to enable it to give judgment. In the case, they may request the CJEU to give a preliminary ruling. And if you look at 1582, CJEU shall have jurisdiction to give preliminary rulings on request pursuant to paragraph 1. The legal effects in the United Kingdom of such preliminary rulings shall be the same as the legal effects of preliminary rulings given pursuant to Article 267. In other words, it's binding, just as a reference made by an English court before IP completion day under the withdrawal agreement, but decided afterwards was binding. And that was the case of CG and Fratilla. And my Lord Lloyd Jones will remember there was a parallel appeal to the Supreme Court in Fratilla. The Northern Irish Tribunal referred the question 2 days before Brexit came to its final conclusion. We got the answer 3 months afterwards. And the appeal to this court was disposed of on the basis that the CJEU's ruling in 2021, post-IP completion day, was binding and dispositive, and that was it. And that was the effect of Articles 86 and 89 of the Withdrawal Agreement. A reference made under Article 158 will have the same effect. But the common theme of all of this is that wherever the Withdrawal Agreement applies to any fact pattern, including the 11 months of the transitional period, as well as in relation to Part 2, any period caught by Part 2, the CJEU decisions, as a matter of either Article 158 or the contents of Article 4, are binding.
If we make a reference?
If you make a reference. But equally, if there were case law from IP completion date, pre-IP completion date case law relevant to a dispute arising in the transitional period, it would still be binding in that respect. And that, with respect, is a modest qualification of the analysis in Lipton, because in Lipton, this court concluded that effectively it was free to depart from the CJEU's case law once it was decided that accrued case law was retained in EU law. And we don't challenge that analysis in relation to the period before the transitional period, but we point out, respectfully, that in relation to any facts that relates to a period governed by the transition period, it's the withdrawal agreement that applies at that juncture. And the question becomes not one of retained EU law, but relevant separation agreement law. And that takes me to...
But in this case, it's not suggested that there should be any departure from any decision.
It isn't, but it may be a factor that is relevant to the discretion to refer.
So you accept that in relation to the period of her entitlement pre-exit day,
Yes?
that's covered by Lipton,
Yes?
and we can't make a reference.
If that was the only period, if it was a one-off cause of action...
Well, no,
Yes.
it's not a one-off cause of action. You keep stressing these different periods of her ongoing entitlement.
Yes.
I'm trying to work out what it is you say is different. So do you accept that for the years when she was prevented from claiming the child element before exit day, there's any reference that we make cannot affect her entitlement over that period?
If all that was decided by reversing the decision in question were entitlements that ran up to and only up to a period that was pre-transition period, then there would be no power to refer.
Right.
But once the decision in question, as a matter of law, as well as a matter of entitlement, decides a continuing entitlement that runs into the transition period and into the post-IP completion date period. In other words, it will generate a debt owed by the Secretary of State to my client in relation to the period after IP completion day. That engages the operation of the IP completion day provisions. That's our submission. That's what we call a straddling case.
Article 158, does that apply in this case?
It does, if you accept my analysis. But there are two rival views. There's the Secretary of State's view, which says all that matters is the law that was in force on the date of the decision under challenge.
The reason I'm just raising, I've probably misunderstood something, but it refers to a case which commenced at first instance within 8 years from the
Yes.
end of the transition period.
Yes,
The end of the transition period was December 2020, is that right?
yes,
And these proceedings began earlier than that, didn't they?
yes. Yes, so the question is,
So how does 1581 apply?
in our submission, all that is being done by that language is to effectively identify a temporal cut-off. It's telling you,
Sorry, it applies to a case which commenced within 8 years from the end of the transition period.
yes,
That's not this case.
the purpose of that provision, my lord, in our submission, is to identify the end point of referability. In other words, what you look for is whether or not the case started at first instance within 8 years of IP completion date. In other words, you're looking for a
IP
case...
completion date being?
IP completion day is being 1st of January 2021. So if the proceedings commenced at first instance by no later than the 31st of December 2028, then you're in time. And what's more...
So you say that the words within 8 years from include a period before the start of the 8 years?
Indeed, my lord. And that's the
I see.
object of our purposive interpretation, because otherwise you get what you can call a sort of donut hole.
You may do, but as a matter of ordinary language, that's not what within 8 years means, is it?
I'm not going to suggest that the Secretary of State doesn't have in her favour certain ordinary language provision. Point. I don't suggest that. But what the Secretary of State can't do is identify any reason of policy or principle that is in any way consistent with the objectives of this agreement that says a dispute in relation to a substantive obligation that's utterly unchanged is referable up to the 31st of December, stops being referable, but if we restarted the dispute...
I understand the point you're making, but you come up against the language of 158. So you can't find the answer to your conundrum in 158, can you? You've got to, in the light of what you say is a policy peculiarity, find it somewhere else.
Or through conventional EU principles of
EU
interpretation.
did you say? You said
Yes,
EU.
I did, because they're set out in Article 4 And you would approach that issue and that inconsistency of result, that inconsistency of principle, through the optic of EU law method and principles. And our submission is the Court of Justice would say in relation to that, well, of course, there shouldn't be a gap in the power of referability. The whole purpose of this provision was to ensure that the protection that Part 2 is designed to provide is continuous, at least up until 8 years plus after the commencement of the transition period, after the end of the transition period.
Mr. Delamere, setting that point, I realise you're under time pressure, but I do need clarification on
Yes.
this point. Setting my Lord's point to one side, and for a moment, only for a moment, and proceeding on the basis that there's a debt effectively generated over the 3 periods which you have identified. It's your case, as I understand it, that the power in Article 158 of the Withdrawal Agreement, as given effect in domestic legislation, permits a reference in respect of all 3 periods.
No, only in relation to the latter period. But
Well, second and third.
second and third.
Well, that was going to be my question.
Yes, it does, but that will provide an answer to the first period because
Yes.
we're all agreed that Regulation 883 is unchanged.
Well, you've answered my question that you accept it doesn't apply to the first period.
I do.
Yes, thank you very much.
The critical thing to
But
appreciate...
what would happen if there'd been a change in the law then, of the kind that you referred to as affecting the regulation?
Well, in terms of the prospective change that's permitted under Article 36, my lady, is that...
Well,
That would affect-
You pointed out, yes.
That would affect whether or not the Secretary of State could make a supersession decision based upon that change in the law to then change the entitlement. So let's say, silly example, let's say you're entitled to £100 and the law changes so that you only become entitled to £50. When that ordinarily occurs, the way that that's addressed in the social security system is that you adopt a supersession decision overtaking the previous decision. So it's the potential for a supersession decision here bounded by the period of main responsibility or main dependency that effectively determines the period of potential liability. And the first supersession decision that we can identify that could be made is when Markus ceases to be dependent upon his mother on leaving secondary education.
But if there was a change in the law, would Article 36(1) then apply?
Yes, it would. It would apply to require the law as changed to be applied from the moment that law changed.
Yes.
Yes.
So then, in principle, it would seem that a reference now, in such a case, appreciate this isn't our case, you wouldn't get an answer to the earlier period.
No, you could only refer in relation to the law that was in force either during the transition period or during the post-IP completion date period. So the critical thing to appreciate is how all of these provisions are implemented by Section 7A of the Withdrawal Agreement. And it's plain that compliance with the Withdrawal Agreement requires very substantial modification of the operation of Section 6. And
So
that's
it's 7A of the
European Union
of the legislation,
Yes.
of the Act,
The Act.
as amended.
Absolutely. And that you'll find at page 413. I know my lords, my lady will have pored extensively over section 6 and its heading and
Some have.
Yes, but we didn't have to take into account the subsequent...
No, exactly. The critical thing about Lipton is that all of the facts and the only relevant facts were pre-exit day. Whereas this case, in our submission, is not.
So
And-
we're going to 413.
If one looks at section 6, and 6.1 in particular, the two primary rules, a court is not bound by any principles laid down
hang
in
on.
the
Page
decision.
423, I think.
423.
423.
I really don't do very well, am I? My apologies, my lord. Page 423. Is not bound by any principles laid down or decisions made on or after IP completion day by the European courts. That's
Sorry, you're going to have to bear with us. 7A is at 430.
Yes, I was just showing you, first of all, the rule in section 6.1. 6.1 is that the court or tribunal is not bound by any principles or decisions made on or after IP completion day by the CJEU, and B, cannot refer a matter to the court after IP completion day. But that's to be read in the light of 6A. Subsections 1 to 6 are subject to relevant separation law, as to which see subsection 7C.
Sorry, where are you getting now? I'm terribly sorry.
That's over the page at 425 at
Subsection
Subsection
6A.
Section.
This is section,
still section
subsection 6A, yes.
So
okay.
section 6, in fact,
Yes.
contains the seeds of its own limitation.
Okay, I follow.
You then go to section 7A, which is at page 430. Yeah. My learned friend, Miss Smythe, has other versions of the same section, but I don't think there's any material difference in the sections
Right.
that I'm aware of. I'll obviously listen carefully to what she says, but this basic architecture, as I understand it, is unchanged. The only thing that has happened is that we must now call it assimilated law,
Yes.
not retained EU law, because that change was introduced with immediate effect when RULA came into force, rather than being delayed. But section 7A is effectively, for the withdrawal agreement, the replication of the old section 2.1 of the European Communities Act. It's the conduit pipe, to use Sir James's terminology from Miller, that gives effect to the obligations under the withdrawal agreement. And it's drafted very closely to the old section 2 of the European Communities Act, and it provides that all rights, etc., from the Withdrawal Act carry over, all rights and
Or
entitlements.
under the withdrawal agreement carry over.
Under the withdrawal agreement, yes.
Yeah, not the withdrawal act. This
I'm
is
so sorry, my lady. Under the withdrawal agreement, you're quite right. I misspoke. And it brings with it its own canons of interpretation, and these canons of interpretation in 7C, page 434, are intended to give effect, amongst other things, to Article 4 of the Withdrawal Agreement. 7C1 says, any question as to the validity, meaning or effect of any relevant separation agreement law is to be decided, so far as they are applicable, in accordance with the Withdrawal Agreement, and having regard, amongst other things, to the desirability of ensuring that where one of those agreements makes provision which corresponds to provision made by another of those agreements, the effect in relation to matters dealt with by the corresponding provision is the same. And it says, too, see, amongst other things, Article 4 of the Withdrawal Agreement, methods and principles relating to the effect, the implementation and the application of the agreement. So if Article 4 of the Withdrawal Agreement operates to make CJEU pre-IP completion day case law binding, that is then given effect by Article 7C2A of this provision.
Sorry, I'm terribly sorry. Where are you reading for that? What
It's
you just said?
7C,
7C, right, okay.
page 434, subparagraph 2.
7C.
And then subparagraph 3 defines relevant separation agreement law, and it basically includes the withdrawal agreement, amongst other things. So what you have is effectively a continued power of referral provided for by Article 158. That, by way of departure from the general repeal of the power to refer under Section 6.1a, is given effect through Section 7a and 7c. And in exercising any exercise in construction of the withdrawal agreement, subsection 7c requires you to apply the principles of interpretation under the withdrawal agreement. In our submission, that means that considerations about Section 12a of the Social Security Act are entirely irrelevant. The question is, what is referable, properly referable, as a matter of analysis under Article 158? Whatever is properly referable as a matter of analysis under Article 158 then becomes part of the procedural landscape which applies to the law, substantive law, as was in place at the time of the dispute arising on the 17th of October 2019. And it matters not that the basis on which referability is made has changed in the interim. It changed during the transition period, and no one suggested that that would have impaired, Section 12A would have impaired any power to refer between the 30th of January and the 31st of December 2020. The critical thing is that the law is Article 883 unvarnished, and the relevant dispute is really, in our submission, either in relation to the first limb that my Lord Richards identified, which is the language referring to commencing with. That's the first potential hurdle. And the second hurdle, and the one we say is the material one, is whether or not it raises a question of interpretation in relation to the withdrawal agreement. And very shortly, our submission in relation to that is that where the facts do straddle and where the litigation generates a conclusive legal view as to an entitlement after IP completion day, that is sufficient to amount to a question of interpretation of Part 2 of the withdrawal agreement, because necessarily Part 2 and its referability brings with it all of the instruments that it gives effect to. I don't think anyone is arguing that were facts to start today in relation to someone within personal scope about the meaning of Regulation 883, with no dispute about the language of Articles 30 or 31, that case would be referable. So if Ms Simkova had started her case on the 1st of January 2021 by way of seeking some form of revision and then challenging that, she'd instigated fresh proceedings. No one's suggesting that that wouldn't be referable. And that,
No one, it just, there's too many negatives.
Yeah.
So
if Ms Simkova on the 1st of January 2021 says, you took a decision back on the 17th of October 2019 to withdraw my child element, you took it under EU law as was in force. In order to preserve my entitlement to have a reference to the CJEU, I'm going to ask you to take a decision to the effect, a formal decision to the effect as to whether or not I'm entitled to child elements. If she then challenged that on the 2nd of January, having received such a decision, no one is suggesting that that dispute would not be referable.
I thought there was a challenge. I thought that there was a more fundamental challenge to whether your argument that those words in the Withdrawal Act bring in anything that's cross-referenced in those provisions, so that those are all now capable of being referred to the court. I thought there was a challenge to that. I thought they were saying it's only actually the wording of the withdrawal agreement, but I may have got that wrong. Yeah.
Ms Smith.
Yes, so the position is that in the example that Mr Delamere has given, which is a decision made in October 2019, our position would be the same even if the case were commenced now, because we say that concerns old law,
Yes.
and it isn't possible to make a reference under Article 158 in circumstances when the law at issue wasn't actually enforced. In other words, what Article 158 is about is making references in relation to interpretation of Part 2 of the Withdrawal Agreement, and that was not in force in October 2019. So essentially the Secretary of State takes 2 points. One, it's the wording point, and the second point is that one has to start by looking at what law is actually an issue in this appeal, and if the law, as we say it is the law as at October 2019, then Article 158 can't apply, because there can't be a question of interpretation of the withdrawal agreement in circumstances where the relevant provisions weren't enforced.
And you say, forgive me my interrupting you, but you say that it is the old law because of the provision of the Social Security Act.
Yes.
Yes, so that's the initial point, whether it is in fact a straddling, continuing, accruing course of action, or whether it all has to be considered on the basis of as the Social Security Act might indicate, depending on how you read it.
Yes.
Then there's a second question as to the starting point for the purposes of Article 158.
Yes. That's right.
And then if we get beyond, if Mr Delamere gets beyond both of those points, then there's a question of discretion.
Yes, and the only reason I rose was just so that it was clear what our case was. I should say that I agree with Mr Delamere that we certainly wouldn't say that if the reference is about a provision of EU law applied by the withdrawal agreement, we wouldn't say that's not an issue of interpretation of withdrawal agreement law. So it's more about the fact that the case relates to October 2019. So we'd certainly agree with him if the decision had been made in January 2021. Yes. I think it's because Mr Delamere said the decision was October 2019.
No, I think we're at cross purposes. I very clearly posited a situation where in 2021, someone challenged the failure as from 2021. So Ms Simkova says, I'm still entitled to child element. I'm entitled to it now under the provisions of the withdrawal agreement, giving effect to Regulation 883. I require you to take a fresh decision so that, if necessary, I can persuade the Supreme Court to refer the case to the CJEU. If that had happened, we wouldn't be having this argument.
Well, you wouldn't be arguing about the starting point for the operation of Article 158.
Nor, as I understand what my learned friend has just said, if the facts were confined to the entitlement from the 1st of January 2021 onwards, will we be arguing about whether or not it's referable? And if that's the case, it shows the basic aridity of the Secretary of State's case. This is some unplanned lacuna that just occurs in the middle of what is intended to be a seamless regime of protection that's to run until the end date in question. That's our essential submission. We recognise that the black letter language, divorced from the context of the withdrawal agreement and divorced from what Part 2 is intended to do would militate against us, but once you understand what it is that Part 2 is meant to do, and you understand the unprincipled consequences that manifest, the Secretary of State's position becomes, with respect, very difficult to defend, because they haven't been able to identify any reason of principle as to why there should be that hole in the donut of referability. It's just entirely unprincipled. There's no grounding in the Part 2 provisions or the objectives of continuity that could begin to justify it. We set out 4 reasons why we say that's the case. I'm conscious of the time Mr Bewley requires, so I won't reiterate those. All I would then say is the question for you is whether, as a matter of discretion, you choose to exercise that jurisdiction if you consider it exists. And we would say, as to that question of discretion, you should approach it with the standard SILFIT test well in mind, particularly since the Secretary of State seeks to pray in aid, in other contexts, different European benefits that have the same character as universal credit. She's prayed in aid Irish and, I think, Slovak, I might be wrong about the second, benefits that have similar character to universal credit. This question as to whether or not you can gather together your benefits in one compendious whole and thereby alter the operation of the regulation is obviously of importance not just in the United Kingdom but throughout the EU. And now, entirely altruistically, since we're no longer members, that is, I would suggest, a relevant consideration to be taken into account when looking at referability through the optic of Article 4.1.
Mr. Delamere, could I ask you just one point on Article 4 of the Withdrawal Agreement?
Yes, why not?
And it's the contrast between 4.4 and 4.5. So this is page 759
yes.
and 760.
Yes.
I think you said that if a reference was made now, that the UK would be bound
yes.
by the decision given on that reference.
Yes.
But I just question whether that's right, because wouldn't that be case law of the Court of Justice of the European Union, looking at Article 4.5, handed down after the end of the transition period?
That's subject to Article 158's own terms.
Right.
Go to page 784, as in the second sub-paragraph, as I read it earlier, it says in terms that the effect of a reference shall be exactly the same as a 267 reference.
Do we have 267 in the bundle?
We don't. We can supply it.
Yes, perhaps if you could.
Of course. And that's entirely consonant with the provisions of Article 86 and 89, which you'll find at 777 and 789, 777, which provide for the bindingness of references made before IP completion day but not answered until after IP completion day. And they are to be final and binding as well.
Yes. All right. Thank you very much.
I'm told 267 is in the bundle at page 752. Thanks, Chair.
Thank you.
Thank you very much.
Great.
Thank you. Mr. Bewley, I'm afraid we've trespassed into your time.
My lord, my lady, I'm conscious of that. I'm going to plan to deal with my submissions by 4 o'clock. So, my lord, my lady, the Air Centre is grateful for being given permission to intervene in written and oral submissions. I shan't labour that for reasons of time. Our case significantly aligns with that of the appellant, and I'm able to adopt the submissions made by Mr. de la Mare AC in their entirety. In those circumstances, what I wish to do in the limited time available is to develop some central submissions on what we think the case turns on, focusing entirely. I'm not going to say anything about the reference issue orally, for reasons of time, and because you have our submissions in writing, focusing therefore on what I'll call the benefits issue. That sufficiently identifies it. I'm going to try and do it in 3 stages as follows. First of all, the identification and the significance of the 2-stage test, and you may already know what I mean by that, but I'll show you in just a moment. The identification and significance of the 2-stage test deployed by the CJEU to answer the question of whether a particular payment or allowance is a social security benefit within the meaning of Article 3.1. Secondly, and Mr. de la Mare has traversed this ground, I think, now this afternoon, so I can take this shortly, the application of that test to the child amount or child element. It's called different things by different people. And thirdly, in light of that, the need for any freestanding test of severance. Just before I develop then those points, then, if I just give you my overarching submission, it is that the 2-stage test, I think again, we'll come to it in a minute, but the 2-stage test that the court has repeatedly identified is exhaustive of the analysis that has to be undertaken. So that you ask in relation to any particular, and I want to use a neutral word, any particular payment or entitlement, whether it satisfies the 2-stage test, and if it does, you're within Article 3.1. What you don't do, and what the European Court has never done, is ask a prior question as to severability before applying the 2-stage analysis. And that leads to the situation where, therefore, the sort of thing which the universal credit rules do here domestically, which is to create a single benefit, doesn't affect the entitlement to exportability, the applicability of the rules in the regulation to any particular element thereof. And that, and I won't labour this point, and Mr. de la Mare has already made it, that's important, because if it were otherwise, you do end up with a very odd situation indeed, which is that the domestic legislature is able to defeat the applicability of the regulation to elements which plainly, on any view, appear to have the characteristics of matters that ought to satisfy the test of exportability, simply by linking them up into a single linked set of benefits. Now, I don't make that as my only point. Obviously, that's a consequence, but it's a surprising consequence if that's where we end up, and it's a point that I was have in mind. Let me then develop those 3 points. So the 2-stage test that I've referred to, I think you'll have seen it by now. It's set out in all of the cases in pretty much the same language. We set it out in our written case at paragraph 11. I won't ask you to turn it up unless you particularly want to. And we cite as authority for it paragraph 53 of the INPS case. And the relevant page number in the bundles is 2301. But again, I won't take you to it for now. And the 2-stage test is simply this. And this is put in the same way by the appellant in their written case, but it's critically, it's what the cases say. The payment must be first granted without individual or discretionary assessment of needs on the basis of a legally defined situation. And that limb of the test is not in fact in dispute. The Section 8 accepts that that's met. And then critically, it must relate to one of the risks in Article 3.1 of the regulation. One of the risks. And we'll see, and I'll pick it up as we go along, I'll give you one example of that, but without exception, that's the formulation the court uses. Now, in fact, though, the Secretary of State makes, in my submission, an important departure from that two-stage test in the way she frames it in her written case. And can I, for this purpose, perhaps just ask you to turn it up, or at least consider doing so if it's helpful to you. So she sets out the two-stage test, paragraph 82 of her written case, which begins on page 165 of the bundle and runs over to 166. The first element of the test, as I say, it's not in dispute, so we don't need to look at that again. But if we go over to page 166 of the key documents or the hearing bundle, same thing, she puts it as follows, and note the critical additional words. She says, it, the payment, the allowance, must concern one, fine, but then in parentheses, and only one of the risks expressly listed in Article 3. So the critical addition there, certainly to the language used by the court, certainly to the way in which the test is identified by the appellant and by us in our written cases in the paragraphs I've told you, is the addition of the words in parentheses, and only one.
That might depend on how you read.
Well, sure, that's right.
But doesn't it follow from Herx?
No, and I'm going to come to Herx, because Herx is one of the authorities that cited. So it depends how you read it, as you say. It's correct in this sense that if a payment is capable of meeting more than one of the risks, then what the court has done is says, well, we've got to decide which of those risks is predominant, and therefore which branch of social security it belongs to. So it meets a risk that's family related and I don't know, one that's unemployment related, for example. You have to choose between them. In that sense, it's correct, but it's not correct in the sense which I think it seems to be intended by the Secretary of State, and it's used by the Secretary of State in later parts of her written case, in the sense that if you satisfy, if it relates to more than one of the risks, that takes you back out of Article 3 altogether. It's never used in that way by the court. It's only used in the sense of, well, we've got to decide which it is. So in terms of whether you're in Article 3, all you've got to show is that it's you meet one of the risks, at least one of the risks. Although then the court will go on to decide which one is predominant. And as my Lord says, there are three cases that are, and it's correct at 83, you've got to meet, but what's said at paragraph 83 of the written case, you've got to meet both of them. So if it doesn't matter if it's not enough to satisfy one or the other. But the case that's cited is Herx. I just want, in the limited time available, because Mr. Lemaire didn't take very long on it, to go back to Herx and see if it supports that. Before we do it, can I just give you one other reference in the written case? It's paragraph 97, a couple of pages on page 170 of the bundle. It's a longish paragraph, so I won't read it out. But
paragraph?
Paragraph 97 of the Secretary of State's written case.
Yes.
Page 170 of the bundle. I won't read it out, but what the Secretary of State effectively says there is that you can have a payment which satisfies one of the risks implicitly, effectively, and that's her explanation of Herx. That even though it didn't, in other words, if you've got something that's for general poverty reduction, well, you'll only need general poverty reduction if you're sick, or you have invalidity, or you're unemployed, and therefore a general poverty reduction measure effectively satisfies all three of those risks. That's how the Secretary of State puts it in paragraph 97. That is inconsistent with Herx in my submission, and I just want to take you therefore to Herx. So that's, if you're using them, it's tab 65 of the authorities, but at any rate, it starts on page 2011 of the bundle.
2011.
I want to go straight to page 2016, please. This is in the... So this is the case about the Minimex, the pure subsistence benefit, as it were. If we go to page 2016, below the number 5, the second paragraph, you see the rival submissions of Mr. and Mrs. Scrivener on the one hand and the defendant, the Belgian authority on the other. Just see how it's put by the defendant then, middle of that paragraph. The defendant contends, however, that the Minimex should not be held to be covered by Regulation 140871, and you know that's the predecessor provision, since only social security benefits linked to employment fall within its field of application. So the submission is it doesn't meet one of the risks. There is no connection between work and the grant of the Minimex, which therefore falls under the head of assistance. So the Belgian authorities are certainly not submitting it meets more than one of the risks, therefore it falls outside Article 3. They're submitting it doesn't meet any of them, it doesn't have the necessary link. What does the Advocate General first of all make of that? Well, if we just turn the page, just briefly pick up 2018, the paragraph immediately before the number 8, you see that formulation, that final paragraph, final sentence of that paragraph must clearly fall within one of the risks, not the Secretary of State.
Sorry, you're on 2018.
2018. You see the number 8 in the middle of the page?
Yes.
Paragraph immediately preceding that, final sentence, it must be established that the benefit falls clearly within one of the risks. Not, you never see within one, parenthesis, and only one of the risks. You never see that here, you don't see it in any of the cases. But as to what the Advocate General made of the submission, next page 2019, it's a sentence, the paragraph beginning, however, as the Commission points it, the first full paragraph on that page. As the Commission points out, if the law creates a right to a minimum means of subsistence, that right, although it may serve to make good the absence or inadequacy of social security benefits, cannot as such be brought within any of the risks. So the Advocate General cannot be within one of the risks, not it's got too many of them, listed in Article 4.1, which must be covered by the national legislation which that regulation applies. And then there's a critical sentence in my submission. Here the factor which gives rise to entitlement to the Minimex is not a contingency falling within one of the risks covered by that provision, but the claimant's state of need. So the contingency addressed by the Minimex was simply poverty. Maybe all sorts of reasons you meet that contingency. It wasn't the contingency for which a family benefit is paid, effectively needing to meet the additional needs created by having a family. And that's a critical point of distinction. If one then picks it up with what the court itself says, 2024, paragraph 13 on page 2024, and for reasons of time I won't read it all out, but you see the court clearly there rejecting the idea that the level of linkage with work, the need to be available for work effectively, gave you a link to the risk of unemployment, and that's the second part of the paragraph.
Sorry, which paragraph was it?
So paragraph 13, my lord.
13, thank you.
Page 2024. As I say, for reasons of time I won't read it out, but it's the second part of the paragraph.
So can you assist me?
Yes.
What do you extract from this?
So in my
is your
submission,
And I want to make a note.
So, yes. So this case cannot be treated, as it is by the Secretary of State, as authority for the addition of those words in parenthesis in paragraph 82b of her written case, i.e. not that it must concern one of the risks, but it must concern one and one only of the risks.
Yes, if by that is meant.
Yes. Well, I think it's...
This is what I've not followed.
Yes, well, that is meant, and if you want to see that that's meant in her case, if you go to paragraph 99 of the written...
No, you're distinguishing between two possible meanings of the words and only one.
Yes, sorry.
I need your help in relation to that.
You know, so in other words, if you've got a benefit which seems to relate to two of the risks,
Yes.
that does not take you out of Article 3. As I understand certainly the Secretary of State's submission, she says if you've got a benefit which meets not just one, but two of the risks, then that takes you out of Article 3 and means you're not a social security benefit, you're not exportable, you're not entitled to the provisions of Article 7 or Title 3 or whatever. That's her submission. And I don't ask you to turn this up, but if there's no doubt that that's how she deploys it, please see paragraph 99A of her written case, where she returns to deploy the requirement for only one risk in that way.
Paragraph?
99A of her written case, page 170.
Yes, thank you.
So, my Lord, with that in mind, and correctly identifying the two-stage test without the addition of those words, what one has to do in my submission simply is apply that test to the circumstances of the child element. Now, to an extent, Mr. de la Mare has done that. The requirement in section 10 is that you must be responsible for the child, and that's passed into a requirement to normally live with the child in regulation 4 of the Universal Credit Regulations. So apply the two-stage analysis to that payment. Well, there's no discretionary assessment of need. Entitlement is based on a legally defined situation. And the entitlement to the child amount relates to one of the risks, namely the contingency of being responsible for a child, which is one of the risks protected by, which is one of the circumstances to which a family benefit relates. So looking at the child element in that sense, it plainly satisfies the test. And then the simple submission is this. Does it make a difference that in universal credit, though not in child tax credit, the entitlement to child amount is linked to payment of other elements of universal credit? And the answer to that is no. Never mind severability. Just ask the two questions with that additional information in mind. What are the legal differences that creates? Well, it means that in order to get your family amount, you have to claim universal credit. You also have to claim your standard allowance in addition to your child amount. And therefore but that doesn't make any difference to the assessment of the two questions. You've seen from Lakeb that on any view, the mere fact of a link with another benefit does not, in and of itself, take you out. I mean, all benefits are linked, and there are often passporting arrangements, which means to say you can only claim one benefit if you already paid another one. So the word used for that is passporting of Social Security. You have to meet the basic conditions, but they're standard conditions for entitlement to any Social Security benefit. And you have to meet the financial conditions, which, to adopt what my lady...
But suppose they'd done it in a different way. Suppose when they set the threshold for your entitlement, the threshold of your income above which you're entitled to the standard allowance, for example. Suppose they said you get the standard allowance if your income is less than, I don't know, £300.
£400, whatever it is. Yeah.
£400, whatever.
Yeah.
If you've got one child, the threshold is then £600.
Yeah, I mean, that's got pretty, that is pretty much how it works.
Right, but what it's doing is saying that actually your need is affected by all sorts of factors, including whether you've got a child or not.
Yes, that's true, but your need is affected by that factor because it's one of the contingencies.
But suppose it wasn't an extra payment, it was just a greater, a more frequent entitlement to the standard allowance. But you would still get the standard allowance if you've got a child, even if your income is higher than the minimum income. So that what was stepped was not the payment, but the threshold of...
Well, I mean, the first thing I say in response to that isn't how it's done, and I mean, it's difficult to take slightly difficult to take a hypothetical, but with respect, I don't necessarily see why that would make a difference. It might not. So that
we have the additional complication of tapering here.
Yes,
of course.
Yes.
It tapers.
It tapers because you take
because of your monthly income,
and you haven't looked at the detail of that.
Yes.
But none of that. All that any of those things are doing in my submission is that they are introducing what Mr. de la Mare showed you was acceptable, which is effectively some additional provision, which means that you can't, in other words, you don't pay this allowance to people who are very well off because they don't need it. So you introduce a criteria of need. but you introduce the criteria of need over and above, and we've seen from the cases, and I don't go over them, that doesn't make a difference. And I won't revisit that, but I think it's the Commission and Parliament case. But that aside, it doesn't alter the satisfaction of the criteria. So one gets to the answer in my submission without asking a question about severability. There's no need for that question to be answered, and you will not find a single European case except for the DLA cases, which in any event it was found to be severable, so that doesn't undermine the analysis. Where the court first asked, can we isolate this particular entitlement or payment or allowance or whatever you want to call it, and only then do we apply the two-stage test. It's sufficient. You've got a as Mr. Castle showed, you've got a discrete sum of money. I forget which regulation it is, but you were shown the regulation which sets out in detail how much it is. You've got an entitlement to that discrete sum of money, which is payable. That entitlement meets the two-stage analysis, and that's the only answer you need to have. Now, that's puts it very simply, but that often a simple way through it is best. My Lord, if I had time, and I realise that I don't, I'd have taken you back to La Keb. But to just give you very much adopt the submissions Mr. de la Mare made upon La Keb. If you just go back to the relevant paragraph, which is, sorry, I'll just find the paragraph for the purpose of the reference. So it's page 2251.
Page
2251.
Thank you.
And it's paragraph 16 of the judgment. That's the paragraph, and Mr. de la Mare took you to it. That's the paragraph which sets out the basis of entitlement to the child bonus, as it's called. And he drew attention to the fact that you can only get the child bonus if you're already getting the family allowance. But that's the point about linkage. The mere fact that your entitlement to the one benefit depends on being linked to a receipt of another benefit, that can't take away from the analysis under Article 4. But there is another feature you get out of reading Article 1 of the Luxembourg law as it's set out at paragraph 16, which is that certainly in its original form, this was to be paid as a tax rebate. So it is merely an increment in the overall tax calculation. Now then, for reasons Mr. de la Mare explained, for those with a cross-border element, it becomes part and so forth. But the original benefit is just an increment in the tax calculation. And that formality, the argument as I understand it in the case was, well, it's not really a benefit at all, it's tax, and that's where the court says, well, that's just elevating form over substance. But it is also no more than an increment. It can't be separated out, certainly in its original form, it can't be separated out from other elements of the tax calculation. And the court didn't say, well, in that case, we need to ask ourselves the question, can we isolate this first before we apply the two-stage analysis? There's a provision which gives an entitlement. That provision satisfies the test, the two-stage test, and you get the answer, therefore, that it's a family benefit. We invite you to apply that analysis in the current case, and we say that you then don't need to get into questions of severability. Now, obviously, if we're wrong about that, or if severability requires further thought, then we adopt the submissions of Mr. de la Mare on that issue. Just about kept to my time, given a slightly late start.
You've done well. We're grateful, to Mr. Bewley, to you and to Mr. Fraser and to the Centre for your intervention. Thank you very much indeed. We will sit again at 10:30 tomorrow morning. The court is now adjourned. Thank you all very much.